Good afternoon, good morning. Thank you so much for joining us today to talk about substance use disorder and the Americans with Disabilities Act. My name is Regina LaBelle. I'm the director of the Addiction and Public Policy Initiative at the O'Neill Institute at Georgetown University Law Center. And I'm joined today by just a great panel of people who can talk about substance use disorder and the ADA. There are many legal issues involved. We're going to talk about some of those legal policy issues today. So I'm joined, as I mentioned, by Jennifer Mathis, who is with the U.S. Department of Justice, Aaron Konapowski, who is with DOJ as well, the Equal Employment Opportunity Commission in Washington, D.C., and also Dr. William Haining, who is the board chair for the American Society of Addiction Medicine. We are going to, each is going to present in turn, each individual is going to present in turn, and then we'll take your questions. The chat box is turned off, but we have the Q&A box where you can put questions, and we will ask our panelists those questions as we, at the appropriate time. So first, I want to start by introducing a video greeting from the chair of the Equal Employment Opportunity Commission, Charlotte Burrows. Chair Burrows has served at the EEOC as a commissioner. She started in 2014, and she was confirmed to a second term that ends in 2023. She started in this, she was renominated in 2019. So I'm going to ask our staff to please up the video from Chair Burrows so she can start us off. Thanks.
Greetings on behalf of the U.S. Equal Employment Opportunity Commission. I'm delighted to welcome you to this timely event. First, I'd like to thank the Addiction and Public Policy Initiative at Georgetown Law Center's O'Neill Institute for inviting me and others from our team at the EEOC to participate in this vitally important discussion. Thanks also to the American Society of Addiction Medicine for bringing us together to discuss the critical issue of substance use disorder and the Americans with Disabilities Act. Finally, special thanks to Regina LaBelle, who has long been a tireless advocate in this area and brings passion, expertise, and persistence to our search for actionable solutions. It's been nearly 30 years since the passage of the landmark Americans with Disabilities Act, which literally and figuratively opened new doors of opportunity for persons with disabilities. Today, more people than ever know that the ADA prohibits employment discrimination on the basis of physical and mental disabilities. But what's not so widely known is how the ADA protects individuals who tackle substance use disorder from discrimination in the workplace. The COVID-19 pandemic took a huge toll on all of us and heightened the already urgent need for attention to the issue of substance use disorder. The opioid crisis is an especially acute example of this problem. But as our nation begins to recover from the pandemic, despite these challenges, I see hope and opportunity for all of us, for individuals who are working to overcome substance use disorder, as well as our key partners seeking to support them and to address the diverse and complex issues around the opioid crisis. This hope stems from the collective efforts of the public policy advocates, medical professionals, and attorneys you will hear from today. And it stems from EEOC's own significant outreach and enforcement efforts, together with our partners at the Justice Department, to leverage the ADA in this area. The EEOC is committed to educating the public about the ADA's protections for job seekers and for employees who have substance use disorders, including opioid use disorder. We've issued technical assistance to help employees, employers, and healthcare providers alike understand the availability of reasonable accommodation in this area. And through our enforcement efforts, we've obtained substantial relief for workers. Just last year, the EEOC obtained relief for a worker recovering from opioid addiction who'd been fired because he was participating in a medication-assisted treatment program. And the employer had demanded that he could discontinue the use of legally prescribed medication. In addition to providing $150,000 in monetary relief for this worker, the employer is now changing its employment practices and training its employees on the ADA's protections. The EEOC also recently helped a job applicant whose prospective employer rescinded a job offer because the applicant was receiving Suboxone treatment and did so without ever considering whether she could safely perform the job. In addition to providing monetary relief, under our consent decree, the company will now conduct individualized safety evaluations of workers receiving medication-assisted treatments, such as Suboxone or methadone. I'm confident that through powerful collaborations like today's event, we will raise visibility about workplace protections for people who face substance use disorders. And as a result, those workers will experience the respect and the dignity they so rightly deserve. Thank you for your time and your commitment to this critical issue. I hope that you will enjoy today's program.
Thank you so much. We appreciate hearing from the EEOC Commissioner. Now I want to introduce Dr. Bill Haining, who is the president of the American Society of Addiction Medicine Board. Dr. Haining is Emeritus Professor of Psychiatry at the University of Hawaii School of Medicine. He has received numerous teaching awards, which I'm not going to go over, but he is an esteemed academic, as well as, I found this interesting, a captain in the Navy Reserve. So he has both a medical and a military background. He's been an ASAM member since 1988 and was a founding member of the Hawaii Society of Addiction Medicine, where he has served as president over time. So with that, I will turn it over to Dr. Haining. Thank you.
Regina, thank you very much. Commissioner, thank you for your comments and bearing on particularly on one of them relating to the advancement and coverage to opioid use disorders on the part of the allowable diagnoses under ADA. It was not really all that long ago that the one substance which was permitted as a condition for ADA coverage was alcohol, to the exclusion of so-called illicit drugs, or for that matter, illicit drugs, but used illicitly. The relationship between the medical community and the Department of Justice, for example, has not always been a joyful one. I'm sorry to say, dating all the way back to the Harrison Act of 1914. I would opine that much of the source of conflict can be traced to ambiguity surrounding addiction as an illness state. And it is not an ambiguity that is suffered merely by the legal or by the legislative communities. Even my own colleagues sometimes have a little difficulty getting a good grasp on the qualification of addiction or of addictive disorders as chronic and relapsing and progressive illnesses, which meet one of the elements articulated in the governing materials relating to the ADA, which is the definition of a disability in this chapter shall be construed in favor of broad coverage of individuals under this chapter to the maximum extent permitted by the terms of this chapter. One of the questions that's been submitted asks about the extension of ADA protection to people who use illegal drugs or who are not in treatment. So building on that just a little further during the minutes that I have here, the illness, I would emphasize, please know I'm not intentionally patronizing anybody with this next statement, but the illness stated does not respect what the legal status is of the individual with the illness, and it certainly does not distinguish between the drugs that are nominally legal or illegal. The addiction is unfortunately an equal opportunity employer, and it has very little regard for boundaries of types of drug being used. The illness simply infers a certain consequence, and among those consequences are impairment or disability. Now, the ambiguity doesn't derive simply from imprecision in language. It's also a consequence of community bias and cultural beliefs. Much of the opprobrium that's been visited upon those with Hansen's disease in my own state, back before it became a state, in previous centuries, derives from a belief that somehow the person is directly responsible, the ill person is directly responsible for the visitation of this terrible illness, which in that case was leprosy or Hansen's disease, but to a certain extent, by analogy, may be seen as addiction now. It's even with illnesses that seemed rather blameless, such as tuberculosis, even then the institutional and governmental response has nominally been along lines of isolation or confinement. So in line with that very pertinent question about what can be done to assure improved services to and appropriate equity for those who have a substance use disorder, one answer is, of course, to increase the level of parity that is seen in rules that govern the actual reimbursements, be it from Medicaid or, for that matter, from Medicare. The governmental or institutional model sometimes has not advanced all that far from the establishment of the Lexington Hospital in Kentucky just on a century ago, which interestingly was referred to variously, depending on what you read, as the Lexington Hospital or as the Lexington Prison. I'll wrap up by reminding myself that disability doesn't need to be permanent, doesn't need to be total, and that in large part addiction similarly carries the prospect of recovery to what a great many of the other disabling disorders are that we'll be touching on in more general terms here. So thank you for the opportunity. I've used my 5 minutes to allow the much better read members of the panelists to assemble their thoughts. And so it's a good time to hand it back to Jennifer Mathis. Thanks.
Thank you so much, Dr. Haining. I think this is a good example of medical legal partnerships where we can make sure that the law is informed by healthcare best practices. And that's why we're so fortunate to partner with the American Society of Addiction Medicine today. So I want to turn this over to Jennifer Mathis. Jennifer is Deputy Assistant Attorney General in the U.S. Department of Justice Civil Rights Division. Previously, she worked at the Bazelon Center for Mental Health Law, which is a national nonprofit legal advocacy organization advancing the rights of people with mental health conditions and disabilities. She also previously worked at the U.S. Equal Employment Opportunity Commission, and also I'm glad to say that she is a Georgetown University Law Center graduate. And so with that, I will turn it over to Jennifer. Thanks.
Thanks, Regina. I am really happy to be here. I'm so happy that the O'Neill Institute chose to do this session, this webinar today. I think it's an incredibly important topic. And, I think the ADA is an incredibly important tool in addressing issues of access to treatment for people with substance use disorders generally. There have been groups like the Legal Action Center, for one, that have been using the ADA in this area for many years. But I would say recently, with the development of medication-assisted treatment and particularly the MOUD, the opioid treatment medications, we have seen really such widespread, such pervasive misunderstanding about what those medications are and how they work, what they do, that it really, I think, cried out for using the ADA as a tool to protect people who have disabilities that are related to substance use, to try to address some of those issues. And so DOJ recently did a guidance, as Chair Burrows mentioned. EEOC has done guidance in this area. And what has been striking to me is that when we issued our guidance, we got so much interest. We got so many calls from other federal agencies, from all sorts of folks who intersect in different ways with substance use disorder issues, really not knowing a lot about how the ADA might have protected people with substance use or disorder disabilities, and saying, gee, this is really pretty interesting to us, and we think that this actually may be a more important tool than many of the ones that we have been working with or thinking about. And so I find that encouraging. And so I thought what I would do today is just talk a little bit about some of what's in that guidance, just give some highlights about that, talk a little bit about some of the enforcement work that the Justice Department has been doing in this area, and then happy to answer some questions. So we issued our guidance just recently, April 5th of 2022. You can find it online at ada.gov, and it is called the Americans with Disabilities Act and the Opioid Crisis, Combating Discrimination Against People in Treatment or Recovery. Most of this guidance really talks about the ins and outs of how opioid use disorders can be covered as a disability under the ADA. And this has been, as I said, a topic of a lot of confusion, in part, large part really because there is this exception that the ADA has, that if you are currently using illegal drugs, that you are not considered a person with a disability and you don't get the protections of the ADA. But there are complications to that. And so I think just because people know something about that exception, I think the general take, everybody always reads a complicated law in a very simple way, and sort of gets the talking point. And so I think the talking point has been people with substance use disorders are not covered, which is not correct. And so this guidance really just kind of gets into a lot of those weeds about what is covered and what's not covered. And there are some areas where I think there's not necessarily a clear answer. Courts have looked at things different ways, but we can talk a little bit about that. But I think it really is useful in explaining how this works. So to start with, I would just say that this guidance is about opioid use disorders, but there is a note in the guidance that says the principles in this guidance are not limited to people with opioid use disorders. They apply to people with all types of substance use disorders. There were particular reasons why DOJ chose to relate this guidance specifically to opioid use disorders. When I came and saw it, I thought, why aren't we doing something that is related to substance use disorders generally? But looking at actually all of the enforcement matters that have come to us, and so much of what is out there in the world, there's so much that is very specific to opioid use disorders and the medications, the treatment medications, that is why the Justice Department chose to focus this guidance on opioid use disorders in particular. But I do just note that, in general, these principles are not limited to those types of disorders. So let me start with what is a disability under the ADA? For starters, you have to have a physical or mental impairment. And for opioid use disorders and most substance use disorders, that would be the case. Physical impairments defined as any physiological disorder or condition affecting a body system, pretty broad. Mental impairment is any mental or psychological disorder. Typically, having an impairment is not sort of the highest standard. There does have to be something that would be considered an impairment, but it is not nearly as high a standard as I think many people may think. Where I think more of the focus is does that impairment substantially limit somebody in a major life activity? And a major life activity can be an activity like eating, sleeping, interacting with others, self-care. It can also be a major body function, like, the function of the neurological system or the circulation system. So again, the very broad range of major life activities that are covered. And so you need a substantial limitation in any major life activity to be covered. So addiction, as we explain in the guidance, is when repeated use of drugs causes clinically significant impairment, such as health problems or inability to meet major responsibilities with respect to work or school or home. It may be something that results in a limitation in caring for yourself, in learning, in concentrating, in thinking, in communicating, in neurological function, in brain function. So there's many ways that substance use disorder can be a disability, a physical or mental impairment that substantially limits one or more of those major life activities. So that being said, if you have such an addiction or substance use disorder that substantially limits any of those major life activities or any other major life activity or major body function, then typically you would be a person with a disability, except for this question about the exclusion. So there is this exclusion that you are not a person with a disability if you are currently using illegal drugs and you were discriminated against on that basis. But there is an exception to the exception, or an exception to the exclusion. So I think when Congress meant to exclude people who are currently using illegal drugs from protection under the ADA, they did recognize that, in fact, people might be in recovery and should get protection, might still meet that standard of having a disability, that if you, for example, are in recovery and you are taking medication or otherwise in treatment and you are no longer using illegal drugs, you may still have a disability. You may still have that addiction. The addiction itself doesn't necessarily go away. So you may be a person, if you stop taking the medication or stopped treatment or therapy or whatever measures you're taking to address the disability, then things come back, right? And then you would be a person with a disability. So we consider somebody to be a person with a disability regardless of what mitigating measures they're taking. If they're taking medication, we consider the person without the medication. We don't say, oh, well, with your medication, you're fine, and you no longer have any substantial limitations. We actually disregard the treatment, the medication, therapies, and all of that when we say, is the person substantially limited if they weren't taking those things? So if so, then you may be still a person with a disability. If you're in recovery, you still have a disability, still have an addiction issue, you are no longer using illegal drugs. So the ADA actually says if you are no longer using illegal drugs and you've either successfully completed a supervised drug rehab program or some other rehab program, that you are successfully rehabilitated and you're no longer engaged in the use of illegal drugs, then you are covered. So you're not within the exception. I hate these exceptions to exceptions, but you have a disability. You don't have to worry about the currently using illegal drugs. If you're no longer using illegal drugs and you're rehabilitated or you're participating in a rehab program, then you are covered, or you're not barred by the exception. So even if you don't currently have a disability, you may have a history, a record of a disability. So you've had an addiction in the past, and maybe you no longer have that disability, but that is still considered, or I shouldn't say no longer have a disability, you no longer have current impairment that substantially limits a life activity now, but you did in the past. That still counts. If you have a history or a record of such an impairment, then you have a disability. And if you need an accommodation because of that, then you would be entitled to that if it's a reasonable accommodation. And you can't be discriminated against because of it. So that is a lot of what the guidance tries to cover. It also talks about what is current illegal drug use. What does current mean? And I will tell you that that is an area where the courts are a little all over the place on what is current and what is no longer currently using illegal drugs. And some courts have said, if you're no longer using, then you have to be no longer using for several months, maybe weeks or months. Others have said much shorter times than that. So I think the answer is it depends, as with many things. But there is, I think, some language which is useful, which is from the Justice Department regulations about what current illegal drug use means. And those regulations say it means use that was recent enough to justify a reasonable belief that the drug use is current, or that continuing use is a real and ongoing problem. So what does that mean? Again, it depends. But I think certainly for people thinking about whether they have liability, whether they need to worry about whether they're discriminating against someone, I think the safest course is assume that if a person is not using illegal drugs, you don't worry about exactly how long they haven't been using. If they're not using it today, then you assume that that is not a bar to them being covered by the ADA, that they may have a disability. If their addiction rises to the level of disability, if it substantially limits a major life activity, that person is covered if they're no longer using illegal drugs and if they have been through or are in a rehab program. The guidance also clarifies that for people who are taking legally prescribed medications to treat opioid use disorders, like buprenorphine or naltrexone, methadone, that is not current illegal drug use. Those are lawfully prescribed drugs, provided that they have been prescribed under the supervision of a professional. The other thing that the guidance clarifies is that I already talked about this. People with a history of opioid use disorders who are no longer using illegal drugs will have a record of a disability and will be covered that way. There are some drug testing issues that are briefly touched upon in the guidance. Because that comes up most in the context of employment. I think Aaron probably is going to talk a little bit about drug testing. And so let me know, Aaron, if you're not, but otherwise I assume you are. Okay, that's good. The guidance has this much in it. So I'll let you talk about that. So that is primarily what's in the guidance. There's also just a really, here's how you file a complaint. Here's how you contact us. And that information is at the back. And there's actually, I usually just send everybody to the ada.gov portal, ada.gov/complaint. But there's also, I think it is in this guidance, it's like the civil rights, I wrote it down somewhere. I'm sure I have it here. But I think it's listed in the guidance. It's like a civilrights.gov or something like that. But you can find it in there. ada.gov/complaint is safe. here it is, civilrights.justice.gov is the other place you can go. So those are sort of the primary issues that are covered in the guidance about sort of who's covered, who's not covered. I wanted to give a few examples of enforcement work that we've been doing. I'll do it quickly because I think I am close to time. But one of the settlements that we had recently was actually there's a new settlement, I think, in Massachusetts that is the U.S. Attorney announcing a settlement statewide that all correctional facilities have to maintain medication for opioid use disorder. There have been a number of Justice Department settlements related to allowing or really challenging bans on opioid use disorder medications in skilled nursing facilities, quite a few of those, and also in correctional facilities, in jails and prisons. There's a really interesting article that you can find if you Google DOJ Journal. It has a civil rights issue from this past January where two U.S. attorneys, one of them Assistant U.S. Attorney Greg Dorchak from Massachusetts and another Assistant U.S. Attorney talk about all of their work and their legal theories about addressing these opioid treatment bans in jails and prisons, which is a huge, huge issue, very widespread. Some of the other interesting cases I think we've done are we just issued a letter of findings to a state nursing board in Indiana because they run a program. It's kind of a it's quote unquote a rehabilitation and monitoring program that is mandatory for some people to gain or regain their nursing license. This was in response to a woman who had lost her nursing license due to an addiction issue and had to go through this program to regain it. Once she got prescribed buprenorphine, she was fine. She described it as a lifesaver and her life was on track again. She never relapsed. She, was now pursuing her life stream to become a nurse again. And she tries to enroll again in this program, this rehab program that's required. And they say, sorry, you have to get off the treatment. And so we issued a letter of findings saying they are violating the ADA and doing that. She was a person with a disability. They were denying her, excluding her from the program, even though she was qualified. And so that one is being negotiated now. We have a settlement agreement from March with a trial court in Massachusetts, resolving allegations that its drug court violated the ADA by requiring people to get off of medication for opioid use disorder. Also in March, we entered a settlement agreement with a Colorado-based organization called Ready to Work that provides employment and social services and residential services for people who are homeless. Again, resolving allegations that they denied admission to the program for people who used opioid treatment medication. We, in February, filed a lawsuit against the Pennsylvania Unified Judicial System, which is all the Pennsylvania courts, alleging that the system is violating the ADA because many of the component courts have these policies that require people in court supervision programs to get off of opioid treatment medications, sometimes within 30 days or pretty precipitously or immediately. And people have experienced tremendous harm when that has happened, in contradiction to the recommendations of their treating professionals that they shouldn't get off it, people in drug courts, people in probation programs. There are people in mental health courts that are subject to this as well. And so those are some of the actions. That litigation is actually proceeding. So gives you a flavor of the different types of scenarios. There are many other types of scenarios that we've seen as well, people losing their children because of a requirement that they get off of opioid treatment, medication, and many other types of policies that have pretty dramatic impacts on people's lives and seem to be based not on science, not on, I think, founded concerns about the treatment meds themselves, but I think based on a misunderstanding that lumps together these medications with, illegal drugs and sees them all somehow in the same bucket. So I will stop there, but I will just say that this, I think, is one of the most impactful areas that we are working in the federal government, not just in DOJ, but in EEOC and in the Office of the National, the Drug Czar program, and in really the DEA, so many aspects, so many agencies and components within the federal government, I think, are addressing this, and folks on the outside. And so I am excited about the prospect of using the ADA to continue to address many of these issues.
Thanks so much, Jennifer. And I am going to introduce Dr. Aaron Konapowski next. Aaron is with the EEOC. I apologize before. He is assists the commission in interpreting and applying Title VII of the Civil Rights Act, the Americans with Disabilities Act, and other federal employment discrimination statutes. He has a PhD in philosophy, which I'm sure helps every day in working in this area. And so with that, I will turn it over to Dr. Konapowski, who has some PowerPoint slides and will take us through. Thank you.
Hello, everybody. Are you seeing the PowerPoint? No, not seeing the PowerPoint. How about now? Now is good. Okay, so I'm here to talk about the employment protections specifically for individuals who use or are addicted to opioids. As was mentioned, I'm part of the EEOC. Keep in mind, just one quick thing, the goal is to present the law as it is, not as any particular person would hope it to be. I write laws all the time. None of them are enacted. And so it's not up to me. This is how it is. Okay, so the thing that I'm going to do is I'm going to talk first a little bit about what the protections are for people with disabilities and people who use opioids specifically or are addicted to them. And then I'm going to talk about the exceptions second, and we can do questions after that. The first kind of protection under the ADA is a protection against disparate treatment. Disparate treatment is a term of art. What it means is basically what you would think of as straightforward discrimination. So an employer fires you or refuses to hire you or demotes you or does one of those kinds of things because of a particular trait or characteristic. And the ADA says that employers are not allowed to do that, generally speaking, because of a medical condition. There's an exception for medical conditions that are transitory and minor, but this is very general protection against taking actions based on medical conditions. Again, we'll get to the exceptions a little bit later, but generally speaking, we'll start there. The second kind of protection is the right to get reasonable accommodations in the workplace. And what the ADA says is that people with certain kinds of medical conditions have the right to get changes in the ways that things are typically done in the workplace that enables that individual to do the job, apply for the job, or enjoy the benefits and privileges of employment. And there can be all sorts of different kinds of reasonable accommodations. You can have assistive technology, changes in policy, special schedules and breaks, leave if the person is expected to return, but not reduce productivity standards. So generally speaking, reasonable accommodations are to help the person work or return to work, not to do less work. So who can get one of these reasonable accommodations? Well, you have to have a disability. That's the first requirement. And this is the definition that Jennifer Mathis was talking about. I think I'm probably not going to, sometimes I try to think back and think whether there's ever been a case in which talking a lot about the definition of disability has helped anyone understand it. I think maybe the answer is no. So the only thing that I'm going to do is try to emphasize that this is a low bar relative to what you might think that it is. The limitations on major life activities, these are functional limitations, don't have to be severe. They don't have to be high. They don't have to be permanent or long-term. And as Jennifer was saying, it's a sort of a hypothetical. You take a look at how the person would be in the absence of treatment and any other kind of mitigating measure, and see whether the person would be substantially limited under those circumstances. So a lot of medical conditions are going to qualify. Second of all, to get a reasonable accommodation, you have to need the accommodation because of the medical condition, right? So if you have a vision impairment, for example, that doesn't entitle you to a fancy chair. There has to be a connection between the disability and the reasonable accommodation that helps you to do the job or apply for the job or get there or something like that. And lastly, you can also get a reasonable accommodation because of a past substantially limiting major life activity. So in the context of opioids, there are a few different categories of things that might be substantially limiting and for which you could get a reasonable accommodation. One is the underlying condition, right? So if a person is getting treated for pain because of a back condition or something, then the underlying back condition could be a disability and you could get reasonable accommodations for that. The side effects, you can also consider those. So the back pain together with dizziness and drowsiness, if that's a side effect of the medication, that could be substantially limiting. Opioid use disorder itself is very likely to be substantially limiting, I think. As you all, I'm sure, know, the diagnosis itself requires the individual to have some substantial limitations in functioning in social or professional contexts. So that's likely to qualify as substantially limiting. And also you can have related or comorbid conditions like PTSD, depression, which are commonly co-occurring. Those can be disabilities and therefore entitle you to a reasonable accommodation. Accommodations that are specific to OUD or might specifically be helpful to people with OUD, scheduling changes to attend therapy or other treatment, accommodations to address the side effects of MAT medication, leave to begin treatment or to undergo treatment, right? All of these kinds of things can be reasonable accommodations if the individual is covered. Okay, so those are the two main protections that I'm going to talk about. And next we're going to talk about the exceptions, which is, I gather, where most of the interest is. And I'm going to talk about 4 categories of exceptions. One is misconduct or poor performance, right? So an employer is allowed to hold an individual who has a medical condition to the same standards of performance and conduct as other people, even if the unsatisfactory performance or conduct is related to the medical condition, right? So if there's lateness, missed deadlines, insubordination, those kinds of things, the employer may impose discipline consistent with its general practice for those things, even if there's a connection with a disability. And as long as they don't, you can't single the person out and discipline them more harshly than other people, but the same as other people is permitted. Other federal laws is another kind of exception. Some other federal agencies like Department of Transportation, Department of Defense, Nuclear Regulatory Commission have regulations having to do with drug use in the workplace. And if another federal law or regulation requires the employer to exclude someone from a particular position, then the employer is allowed to do that without fear of liability under the ADA, right? So the ADA doesn't somehow override this other federal requirement. And notice that it is federal, right? So I'm talking specifically about other federal laws and regulations, not state laws and regulations. Safety is the third category. Employers may exclude people from the workplace who pose a direct threat to safety of self or others. Now, having said that, the employer isn't allowed to just make up the threat to safety. The threat to safety can't just be imagined or speculative or a remote risk, something that the employer is just worried about. It has to actually be a threat to safety in order for the person to be legally excluded. The determination that a person is posing a safety risk has to be based on an individualized assessment. This is one of the important things, that you have to take into account the particular individual and how the symptoms are affecting that particular individual, as well as the workplace context. Are there, big heavy machines around, or is it just an office? And it has to be using reasonable medical judgment and up-to-date medical knowledge. And then in addition to that, the level of risk that the employer is required to assume is set by the statute. It's not set by the employer or by the doctor. In order to legally exclude somebody on the basis of a safety risk caused by a disability, there has to be a significant risk of substantial harm that cannot be eliminated or reduced by reasonable accommodation. Right, so this is supposed to be a relatively high bar. Employers are not supposed to be able to meet it easily. There are also some factors that we say that employers should consider, like the imminence of the harm, the likelihood of the harm. And keep in mind, we call it a direct threat to safety. We don't call it just a little bit of a threat to safety. It has to be a direct threat. And so how is this going to apply to somebody who is using opioids? It'll depend on the individual. Like I said, it'll depend on how the opioids are affecting that particular individual, the work environment, the job functions that person is performing. And we know that SAMHSA has said that in at least a lot of cases, or at least they've said things that suggest that in a lot of cases, employers are not going to be able to meet the direct threat standard for a person who is on MAT just because they are on MAT. SAMHSA said that when provided at the proper dose, medications used in MAT have no adverse effects on a person's intelligence, mental capacity, physical functioning, or employability, right? So there has to be this very specific finding that this particular individual is a safety risk. Coming up on the fourth category, and the last one I'm going to talk about is this illegal use category. Again, this is one that people are quite interested in, I'm gathering. And the language of it is kind of interesting, but I'll go over it again just as an initial setup. The ADA doesn't protect individuals who are currently engaging in the illegal use of drugs when the employer acts on the basis of such use. So currently engaging in the illegal use of drugs. And illegal use here is defined by the Controlled Substances Act specifically. And so I've put up the part of the Controlled Substances Act that discusses opioids. And these are the things that are illegal under it: possession of heroin, possession of prescription opioids that are not yours, basically, not obtained from a practitioner, and then possession of prescription opioids that are obtained through misrepresentation, fraud, forgery, deception, subterfuge. Right, so it's those things that constitute illegal use. Either the drug itself is illegal, as in the case of heroin, or the possession of it is illegal, as when you don't have a legal prescription. And as has been mentioned, prescribed MAT medications are not illegal, right? So they don't constitute illegal use. And this one, I just want to back up and mention, this is because I found that at least, maybe it's lawyers, I'm not sure, but there are at least a few people who seem to get mixed up between the idea of illegal use and some of these other more clinical terms, like misuse, abuse, dependence, addiction. Those terms are not part of the ADA. I don't necessarily want to represent that I even know what they mean necessarily, or able to distinguish between them. But illegal use means illegal use. It's that it's against the law as defined by the Controlled Substances Act. It's not that you're abusing them. That's not necessarily illegal use. It's not that you're misusing them, right? If it's illegal if it's not your prescription, or if you obtained it through fraud or misrepresentation, or if it itself is illegal, like in heroin. There is also this safe harbor, as it's sometimes called, where it's the exception to the exception, right? So you have these people who are excluded because they're currently engaged in the illegal use of drugs. And then there are all of these exceptions to the exceptions. Well, the person isn't excluded if they have successfully completed a supervised drug rehabilitation program. And then there are these three categories of people. I tend to encourage people to not think too hard about this particular provision, partly because it is an exception to exception and it's confusing. But if you read it closely, this will start to jump out at you, which is that in each case, it's currently engaging in the illegal use of drugs is part of the exception to the exception in each case. So I would say that the concept that's doing the most work in the exclusion and in the exception is current illegal use of drugs, rather than whether or not the person is in a supervised drug rehabilitation program or not. The question is whether they're currently engaged. So the big question is, what does it mean to be currently engaged in the illegal use of drugs? And this is where I think I disappoint people, because there's no answer to that question. It was left as a kind of a loose, elastic kind of standard. The courts have decided that no formula can determine if an individual qualifies for the safe harbor or for former drug users, or is currently using drugs, although certainly the longer an individual refrains, the more likely he or she will qualify for ADA protection. And you have in different circuits all of these rules that are, to my mind anyway, more or less equally unilluminating. They say things like a person is currently engaging in the illegal use of drugs if the use is sufficiently recent to justify the employer's belief that the drug abuse remains an ongoing problem. There is periodic or ongoing activity that has not yet permanently ended. The individual has not refrained from illegal use for a significant period of time. And then my favorite is at the bottom, the person is currently engaging in illegal use if the individual has engaged in illegal use recently enough to justify a reasonable belief that the person's drug use is current, which is about as circular as you can get. So I'm not so sure that these collections of words are that illuminating. I think that this law was written in a time when people wanted to be hard on illegal drug use. And so this exception was made and it was left a little bit loose. The determination is going to be case by case. If you read the decisions in a little bit more detail, you get the sense that what they wanted to avoid was a loophole. They didn't want people who were sort of caught and then going to be fired to run out and join a rehabilitation program the very day and say, oh, I didn't use drugs, I didn't illegally use drugs today. And so I'm not currently illegally using drugs. And so therefore I can qualify. That's what they were getting at. But the translation into a rule for deciding it hasn't been, to my mind, all that successful. And you've had cases, a few weeks, a few months. It's unclear. I think that if you read it in a way, a lot of these are kind of harsh. For a significant period of time, no longer an ongoing problem. I mean, the nature of addiction, it could be an ongoing problem for quite some time if you really take those formulations seriously. And so I think that if you were an advocate for somebody who is addicted, you would try to show that they, generally speaking, are not, it's not as much of a problem as it was before. But whether that's going to convince a judge or a court or a jury, I don't think there's any way of saying for sure one way or the other. I've lost track of the time, but I'm going to say just a quick thing about testing. There are two systems for drug screens. One is this highly regulated one, where HHS regulates the whole process, and there's a medical review officer in the middle. Generally, if the person tests positive, but they have a prescription, it's reported as a negative result. This is what I am told by the people who do these kinds of things. But then there's everybody else, where it's just kind of a free-for-all. There are no rules about how these things have to go. And the testing companies can contract with the employers in the ways that they see fit to test for the things that they want to test for. Generally, the sort of standard is this 5-panel test, which screens for heroin / morphine / codeine, which are all kind of the same thing in the end. That is the standard. It's almost always included, but employers can add screens for methadone, buprenorphine, also, et cetera, in broader panels. Okay. There are ADA protections against medical exams, which I think a drug test would normally be a medical exam. You can't do one of those things prior to a conditional offer of employment, usually. And during employment, usually you have to have a really good reason to believe that the person is experiencing a problem because of a medical condition or drug use or something like that. But there is this exception, which is that the ADA does not restrict tests to determine the illegal use of drugs. I've always found this formulation vexing because tests to determine the illegal use, there are no tests to determine illegal use. There are only tests for drugs, and the illegal is not part of the test. But having said all of that, these screens, these standard screens for drugs that can be abused or are typically abused or something like that, those have been generally considered to be tests to determine the illegal use of drugs. And so there hasn't been a lot of scrutiny about giving those kinds of tests to people. And so I'm going to stop there. I think I'm probably at time.
All right. Thank you so much, Dr. Konapowski, for that overview. And, you know, as an attorney, I can say one of the most frustrating things that I have to tell people often is it depends. And that's much of what we look at in this. This is really, you know, this one webinar obviously isn't going to answer all your questions. There are many questions in the chat from you that I'm going to tee up a few. I also want to mention, though, one of the questions that came up was what type of resources and guidance is available. So the Bureau of Prisons and the National Sheriff's Association put out a document 2 years ago. We'll send all this to you later on. That talks about how to implement medication treatment programs in correctional facilities, because that has been an area where there's been quite a bit of litigation nationwide. So that's one resource. The second resource that's really helpful is from the National Council, that again goes over a lot of the responsibilities and how to implement medication programs for individuals with opioid use disorder in correctional facilities. Those are our two resources. We'll make sure you get that. I want to start first with a question. We have about 15 minutes with a question for Dr. Haining. And this is, you know, it's a medical question, right? What's the definition of recovery? Dr. Haining, if you could talk about that, not from a legal perspective, from a medical perspective.
Well, I have a father-in-law and 3 brothers-in-law who are attorneys, so I think I'm entitled if I want to opine legally, but I won't, in deference to Dr. Konapowski. That was brilliant, by the way. I know we're probably not supposed to be complimenting each other on this call, but that's the first time I've heard that coherent an articulation of some very confusing principles relating to the law. The part of the difficulty, and you're right in calling this a medical issue, is that, of course, it's viewed depending on who the viewer, what the viewer's context is, as either bad behavior or as an expression of illness. It's interesting, and I will be brief, but it's interesting that when we try to look at addiction as a disorder, whether or not somebody is actively taking the drug, many of the people who have the illness would in fact articulate that the craving for the drug is demonstrative of their ongoing addiction, of their illness. Okay, so this is part of the problem with what happens in a prison where ostensibly you can't get drugs, but as anybody in this panel knows, you fully well can. That somebody is somehow considered protected against the drug use and thus can be discharged in a state of abstinence. And unfortunately, it is much more of a state of vulnerability than a state of abstinence. If we did this with diabetes, people would scream. If you came into my office for treatment of your diabetes and I said, here's a bottle of Lenti insulin and a package of syringes and some alcohol swabs, oh, and some urine test tapes for your sugar levels, go forth and hyperglycerate no more. You'd say, well, when am I supposed to come back for a follow-up? And you don't need to come back for a follow-up. This is all you need for treatment. Yet, of course, intriguingly, we do that with substances of use and with great regularity. I've put down and I've sent it already out to everybody as to what a definition of recovery is, which comes from the American Society of Addiction Medicine. So that's linked right now to the Q&A section, I believe.
Great, thank you. So I wanted to tee that up because I think it's important that, you know, the American Disabilities Act was passed at a time, as Aaron pointed out, when we're taking a different approach to substance use, and it distinguishes between alcohol use when you're in recovery, illegal drug use. So I want to ask Aaron about the applicability to safety sensitive positions. Several people asked that question about the applicability of the ADA to people in recovery from safety sensitive positions and whether or not they are. So I'll let you answer that.
Right. So we do get this question, and the thing that always gives me pause is that that's not an ADA term, and so it's not always clear to me what it means, how people are using that term. Certainly, there's no distinction in the ADA between here's what you do for safety sensitive positions, and here's a whole other set of rules for the other kinds of positions. I think where it would come up would be in the direct threat context, where you're trying to figure out whether the person poses a direct threat to the health and safety of self or others. The context, the content of the job would be figured into the determination. So, you know, if your job is to work in an office as an accountant, it's going to be harder to show that you're going to be a direct threat to safety than if you are, you know, working with sensitive equipment that could explode or something like that, right? And so usually you call the latter ones safety sensitive, but it's really just a matter of taking the content of the job into account. Safety sensitive can sometimes mean one of these positions that's regulated by one of the other agencies, like the Department of Transportation, Department of Defense, Nuclear Regulatory Commission. And for those, we really just have to refer people out because we don't oversee those rules. You know, those agencies have their own regulations concerning drugs and drug testing. And, you know, even if I knew all of the ins and outs, I probably wouldn't say what they were just because that, you know, that's not our lane and I wouldn't want to step on anybody's toes. But there are specific rules and regulations that have to do with certain classes of jobs that would be safety sensitive. The only other situation in which it might come up is justifying a drug test or something like that. It may be that periodic testing in certain kinds of positions makes sense, but as I say, if you can construe it as a test to detect the illegal use of drugs, then those aren't controlled anyway. So I think that distinction, I mean, to shorten it all up, that distinction isn't legally relevant in this for me. What it might mean is that you need to look at other regulations, other agencies to try to find out what the specific rules are.
Got it. Jennifer, anything to add?
No, I mean, the only other thing I was going to say, which I think Aaron really alluded to, was, in some contexts, there are other federal regulations, like for airline pilots, about things that they, meds that they can or can't be taking or things like that. So, other laws may apply beyond the ADA, but otherwise, yeah, it's a straight, direct threat consideration, which may, be amplified in safety sensitive positions or not.
Great, thank you. So this is a question that came in. We talk often about people who are in treatment for a substance use disorder, and they're protected under the ADA in settings, that we've talked about here. But what about people who want to start treatment? And whether these various settings like jails, emergency departments, are they obligated under the ADA to initiate this type of evidence-based care to people who are there and may ask for this? I think that's probably a Jennifer.
Yeah, I mean, so that's a good question. I would say certainly that, what is clear under the ADA is that they can't have a rule that's like a blanket ban on treatment meds, right? Saying, which is what is the case in many of these facilities, right? We will provide certain types of treatments, but you cannot have this treatment. Whether or not you need it, whether or not we might make it, we could make it available, whether or not we have access to it, it's just you cannot use these medications if you're here. That clearly is an ADA issue. That is, basically, it's essentially the same, treating somebody differently based on their medication for a disability is essentially the same thing as treating them differently because of the disability. And, they're saying, you're essentially, you can't necessarily exclude somebody from jail or prison because they're there, but you're certainly treating them unequally. It's a different question. I think, do they have to have an affirmative obligation to provide different types of medications? Certainly, for putting the ADA aside for a moment, there's a constitutional obligation in jails and prisons to have constitutionally adequate medical treatment. And so I would say that, typically that ought to cover, things like this that are, people's basic needs. And, I am not a sort of prison conditions law expert. So, I don't know, but certainly I think the ADA is probably most useful for dealing with treatment bans. And I would say that it's more conditions litigation that would be useful, more usually relying on Constitution or other laws that would be useful for purposes of saying you have an affirmative obligation to provide this, that, or the other thing. That said, if they have, a constitutional obligation to provide certain things and they're providing a bunch of those, but again, they've somehow decided that they are not going to provide this one for, some reason that, they think there's a stigma to it or something, then that is the ADA issue.
That's great. So as both of you said on both of these questions, there are a number of laws that are at play here, and especially in the corrections piece, the difference is between the blanket prohibition versus an affirmative action. And there might be an affirmative action that's necessary under some other provision of the law, perhaps constitutional provision. And that's what some of the cases that have been brought have indicated, some of the cases that have been brought against correctional facilities. Another question that came up.
If I can just jump, is it okay if I just jump real quick?
Yes, absolutely.
Just in terms of starting treatment, this is one of the things that I thought was, when I was working on this originally, was the most important and a source of confusion amongst people. There's quick sort of gloss of the ADA when people say, oh, addiction to drugs isn't covered. But again, that's not true. It's illegal use that's not covered. And you can be addicted to opioids and need to enter into treatment without doing anything illegal, right? So there are people who are prescribed opioids, like a maintenance dose of opioids. And I mean, the people on this call know better than I do how common this is, but it's possible that somebody who is addicted and needs to enter into treatment might not be doing anything illegal, and so would be covered. And so I would caution employers at any rate to don't jump just because addiction doesn't equal illegal, right? So don't jump from one to the other. And by the way, I should also mention, none of this ADA stuff says that you have to exclude somebody who's illegally using drugs. I mean, I think that should be said as well, right? You can go above and beyond what the ADA says, but certainly you might still be required to provide a reasonable accommodation, like leave to enter into treatment if the person is not currently engaged in illegal use.
Great, thanks. Dr. Haining, you had your hand up.
There, sorry. Well, actually only to emphasize, I had a mentor named Terry Schultz who said, you can't overtreat this disease. So I was partially responding to the question of what the mandate is for a physician who is approached by a patient or by a potential patient who is presently using opioids or any other drug inappropriately. And I somewhat bullyingly tried to get my colleagues to accept that the greater sin is, in fact, if they don't follow their ethical compass and treat everything that comes at them. Whether or not it's going to be successful, there needs to be an understanding on the part of the patient that somebody else recognized they had an illness and were willing to do something about it. We too often are in the situation of, I go to AA or to NA meetings. In the meetings, physicians may be occasionally viewed as being helpful, usually for some physical problem. They're never seen as helpful for the substance use disorder. They're conflated with the dealers most commonly. Sorry, thank you for letting me chime in on that one.
Thank you. So I don't think we have enough time for any other questions, but this has been an incredible conversation. I want to give each of you a moment just to give a really brief, we've got like 2.5 minutes. So I'll start with Jennifer and then Dr. Haining and then Dr. Konapowski. Jennifer, do you want to just say a few closing comments?
Jen, you're muted.
I'll let Jennifer unmute for a sec. Oh, go ahead. Sorry.
Thank you. Sorry. Yes. I forgot I was muted. The one thing I'd say is please contact us. You know, for the enforcement agencies, certainly for DOJ, for EEOC, you know, if people think there is an issue, you know, reach out. I mean, either in terms of, you know, filing a complaint, but even just, you know, reaching out to one of us to ask, you know, because we're always interested in finding out what is happening in this area. And I think we can be helpful in kind of guiding people. But we're also interested in getting complaints about, you know, discriminatory issues, because that's the way that we can act. And so I am always encouraging people to file complaints. I know that not every complaint gets responded to, but it's really the driver of enforcement.
Thank you. Dr. Konapowski.
Yeah, that's I like that. That's good. You can always contact us. I always try to emphasize to people that although I'm a lawyer, I don't sue anyone. I'm not the suing kind of lawyer. So yeah, I'm there to answer questions. You can always contact the Office of Legal Counsel if you have a question about how the law applies and whether to file a charge of discrimination. And you know, it doesn't cost anything to file a charge of discrimination. And so you can engage with us anytime that you want. And so I would encourage people to do that. We also have some technical assistance on opioids. I take it that those are going to be made available. It's just some links. And there's one for the patient, and then there's one for the medical provider as well. to talk about how to request a reasonable accommodation and so on.
Thank you, Dr. Haney.
I'll keep it uncharacteristically brief by saying that this is a patient class which, once it starts getting well, gets phenomenally well. And so the ability to provide protection to this group of patients that you in fact afford through the efforts of the DOJ can itself be therapeutic and needs to be kept in mind by my colleagues. Thank you.
Great, that was perfect ending, and a perfect partnership between the law and medicine for this population. So thank you all for your time. We will send out materials. This will be available online also, and thanks again. Bye.